Welcome to this explainer. Today, we're unpacking a really fascinating working paper by academic researcher and lawyer Gaston Ray. It covers a paradox that's literally shaking the very foundation of the legal world right now. But honestly, it's a massive warning bell for anyone working in a knowledge profession today. We're going to look at the structural transformation of how professional work is produced and what actually happens when we outsource our core thinking to machines.
So let's start with a mystery, one that absolutely shatters our assumptions about how the highest levels of the legal system operate. You really have to ask yourself, why on earth are highly paid experts, people with rigorous, multi-layered review protocols, suddenly falling for AI-generated hallucinations? I mean, it's not just a one-off mistake anymore. We're seeing lawyers submit perfectly formatted, entirely fabricated cases to federal courts. And to understand how this is happening, we need to look at just how quickly this whole thing escalated.
Let's take a quick look at the timeline here. It actually starts back in 2023 with the now famous Mata versus Avianca case. That was the inaugural moment where a lawyer used ChatGPT for research, and the AI just confidently invented 6 non-existent judicial decisions. The lawyer didn't verify them, submitted them anyway, and faced major sanctions. Fast forward a bit to 2025 and early 2026, and we see an entire sequence of cases in Argentina where appellate courts are constantly catching these fabricated citations. But the real climax? That happens in April 2026 with a genuinely shocking apology in a U.S. bankruptcy court from Sullivan and Cromwell.
Now, this 2026 Sullivan and Cromwell case completely demolishes the myth that AI errors only happen to, inexperienced, overstretched, or technologically unsophisticated lawyers. We're talking about one of the most prestigious law firms in the entire world, charging upwards of $2,000 an hour. Actually, by public account, they're even counsel to OpenAI on the safe deployment of AI. The firm had explicit safeguards designed to prevent exactly this situation, and yet they systematically failed. An emergency motion was filed with hallucinated citations. So why? Well, let's dive into the tech reveal and explore the mechanics of why these models trick even the absolute best of the best.
Section 1, Plausibility instead of truth.
To really understand this trap, we have to look at the architecture of these large language models. See, AI models aren't databases of legal truth. They are entirely based on plausibility. They use probabilistic next token prediction to generate fluent syntax. Their goal isn't to give you the truth. Their goal is literally just to predict the most likely next word so that the text perfectly mimics the stylistic conventions of human writing. This is entirely different from authority, which relies on institutional truth and epistemic traceability. That essentially means you can actually trace a case back to a real judge in a real court on the specific date. And this brilliantly illustrates the core danger. As Gaston Ray writes, generative AI does not reproduce authority, but plausibility. It creates what he calls the appearance of authority. You see, a fabricated case doesn't look like an obvious error. It doesn't have weird spelling mistakes or bizarre robotic logic. It is a perfectly coherent, beautifully written legal argument with a plausible case name, a plausible date, and totally plausible reasoning. It simply does not exist. It completely evades our internal error detection systems because it looks exactly like what we expect a competent argument to look like.
Section 2, when human review fails.
So if the text looks incredibly real, why does the widely adopted human-in-the-loop review process systematically fail to catch these fake citations? Well, the human reviewer falls into a cascading series of pretty predictable structural flaws. First, you've got the automation of trust. If an AI gives you a great answer 100 times in a row, you implicitly start trusting it, right? And you relax your verification standards. Second is cognitive fatigue. Manually checking citations is incredibly tedious. By the time you verify the 20th citation, you are understandably way less attentive on the 21st. Third is productivity pressure. The whole point of using AI is to save time. If you spend just as much time verifying as you saved drafting, the economic incentive vanishes, so we naturally rush. And fourth, institutional overconfidence. Having a flashy AI policy on paper creates this false sense of security, making professionals assume the system will just somehow catch the errors for them.
Section 3, the cognitive delegation trap.
Because the real danger here isn't just the AI hallucinating. The real danger is cognitive delegation. This is defined as the transfer to an external system of mental operations that historically make up professional judgment. Now, it's totally fine for a lawyer to automate calendar management or formatting. That's not the issue. But when a professional outsources the search for authority, the testing of arguments, and the fundamental formation of judgment to a machine, that is when the whole system breaks down. They are delegating the very thinking that justifies their role as a professional in the first place.
And when we delegate this cognition, we directly threaten three foundational legal duties that courts require from every single practicing attorney. We're talking about the duty of competence, the duty of candor toward the tribunal, and the duty of professional good faith. Courts around the world are making it very, very clear. The use of AI does not suspend these duties. If you submit a brief full of AI-generated hallucinations because you failed to verify them, you are straight up failing in your fundamental duty of competence. I want to show you how courts are actually fighting back against this. Down in Argentina, they're combating this with a brilliant doctrinal concept called actuación inoficiosa. Basically, the courts are declaring that unverified AI work is completely devoid of procedural utility. Because it contributes absolutely nothing of value to the proceeding, the courts are withholding the lawyer's fees for that work. It's a powerful intermediate step. It sits just short of temeritaria, or procedural bad faith, but it hits the professional right in the wallet by saying, look, if you just printed out unverified AI text, you didn't do any actual legal work, so you don't get paid. All right, let's head into the climax of this explainer and see how this builds to the ultimate human safeguard.
Section 4. The power of the signature.
We really have to stop treating human review as just a mere rubber stamp for automated outputs. A rubber stamp represents a total abdication of agency. It's where the human just assumes the machine is infallible. Instead, we need to return to the heavy institutional weight of a true signature. The signature is all about institutional imputation. It means stepping up and actually assuming responsibility.
Because, think about it, no matter how advanced generative AI gets, even if error rates drop to a tiny fraction of a percent, it simply cannot bear institutional responsibility. An algorithm cannot go to jail. It can't pay a fine. An algorithm certainly can't lose its medical or legal license. Only a human being can face the ethical burden and the real-world consequences of a major error.
This quote from the paper really brings it all home. The signature certifies that someone has read what is filed, has assessed it, has formed a judgment about it, and is prepared to be answerable for it. The signature is the absolute ultimate mechanism of institutional trust. It proves you haven't just mechanically generated a document to save some time, but that you stand completely behind its substance, and you will answer to the court, or to your patient, or to your client for its accuracy. So we'll leave you with this final provocative question to chew on. Will the practice of law, and really all knowledge professions, absorb AI responsibly, or will we just surrender our judgment to the mere appearance of authority? AI is an incredibly powerful tool for sure, but if we fall into the cognitive delegation trap, we risk losing the very essence of what makes professional work valuable in the first place: human accountability. Thank you so much for joining me on this explainer, and keep your critical thinking sharp out there.